Welcome to Faith and Law. I'm Brad Dacus, president and founder of the Pacific Justice Institute. As many of you know, we at PJI work hard to defend religious freedom, parents' rights, and the sanctity of human life. Well, one of the areas that we focus on quite a bit in the last few years has been religious freedom in the workplace. This is a big issue. We took on cases defending countless numbers, not just thousands. We impacted hundreds of thousands of workers and help prevent our brothers and sisters in Christ from losing their jobs, not because of the merit of their work or coming in late. No, because of their sincerely held religious beliefs. Well, we have a real hot case out of Florida that we have participated in and are participating in as amicus, or in filing a friend of the court brief. The big question in this case is simply, can Americans be forced to choose between their faith and their livelihood, with no responsibility at all with employers to make any effort to reasonably accommodate those beliefs? Unfortunately, this is not just a theory. It's not just a concept. This is a real case in the state of Florida, impacting real people. So what exactly happened in this case? The case is Marin versus Nemours Children's Hospital. Now, this involves a Christian employee who simply requested religious accommodation with regards to the COVID vaccine mandate. This is not unusual. This happened all across the country. Well, what happened is the employer flat out denied the request. No religious accommodation, not for you, you're done. And the employee was terminated. What was the legal issue? The legal issue is not the federal law, Title VII, because this was actually filed in state court. We're going to talk a little bit later why this was done that way. But it was filed in state court, and they relied upon the Florida Civil Rights Act, which prohibits religious discrimination in the workplace. Does it require reasonable religious accommodation? That's the question here. Because it's real important, because if you have a statute that has general language, but no specific requirements, it may be basically worthless. Maybe like a nice gesture, but if it doesn't actually require employers to do anything to accommodate employees' religious beliefs, it's sort of toothless, if you will. And it's not going to really help and actually accomplish anything as it was intended to. Well, here's what happened that makes this so juicy and interesting. So this case goes up on appeal. And the lower court did not rule favorably for this employee. And it went up on appeal. And the appellate court did something that I am not used to seeing them do very often. They decided to contact Pacific Justice Institute directly and asked us to send them our legal analysis to file an amicus, friend of the court brief in this case. This is not very normal for them to say, no, we want outside opinion, and for them to specifically say, we want Pacific Justice Institute's opinion on this case. It's not just flattering, it's very significant also because it shows the importance of the constitutional interpretation. Folks, people know us for what we do. We're constitutional lawyers, and we have a lot of aspects to us in terms of legislation, in terms of church engagement, in terms of direct evangelism. I guest preach at churches all the time. But what we're most noted for is our work as constitutional lawyers in protecting and defending the original intent and strict construction of the Constitution. So they contacted us. We, of course, naturally obliged, provided them a very well done legal analysis, a amicus brief, friend of the court brief. And the attorney who did that for us heads up our office there in Florida. He did a fantastic job. Now, what's the legal framework here? Well, Title VII, the similar federal statute, and it was enacted as a part of the Civil Rights Act of 1964. It's been interpreted and requires a reasonable accommodation of sincerely held religious beliefs, absent a substantial or undue burden upon the employer to do so. That's established case law, and we've been using it time and time again, and we've been filing in federal courts, and we at Pacific Justice have helped set some great case law on this. That's what it says in federal court. However, the Federal Civil Rights Act is modeled after this Title VII federal law. But the key issue is, should the Florida law be interpreted consistently with the federal law? In other words, should it also implicitly require reasonable accommodation of sincerely held religious beliefs of employees? And it's not explicitly spelled out, but the language and the purpose of it, when it was adopted, the state statute parallels right there closely, arm in arm with Title VII, the federal statute. And that's what we argued. We said, if it's to have any meaning, any teeth at all, it needs to apply the same principles as Title VII. It was adopted at the same time, the same era as Title VII. It has the same purpose as Title VII. It looks like a duck. It talks like a duck. It's also probably a duck. That's what we argued. And I think in the end, I think it's going to be very successful for our clients. Now, some people say in the back of their minds, they're saying, look, why didn't the attorneys simply file in federal court? You wouldn't have to worry about what the state statute says. Just file in federal court. They could have done that, but there's a reason they didn't. You see, federal law, Title VII, has a much narrower window in terms of statute of limitations. In other words, you don't have as much time to get your act together and file your lawsuit before the time runs out and you can't file at all under federal law. The state statute, like many state statutes dealing with these issues, says you have more time under state law to file your claim for religious discrimination and lack of reasonable accommodation in the workplace. So this is very significant. Why? Because there's so many people, not just because of the COVID vaccines and all the firings from that, but just in general. It takes them often time to get together and think about it, pray about it. Should we file a lawsuit? Do we have rights? I think your Uncle Jeb knows about this stuff. Give him a call. Yeah, we'll do it. We get to see him over Thanksgiving. And what happens? The time runs out. Well, the good news here is Florida Civil Rights Act, that allows for much more time. And that's why this is so significant, not just with regard to Florida, but other states as well with similar language. So we at Pacific Justice Institute, we stepped in on this because if the Florida statute is not interpreted parallel with the same application and language of the federal statute, it's basically worthless. And it could give you till Timbuktu. I mean, you can give you 100 years to file. If the statute itself has no teeth, it doesn't matter how much time it gives you to file, it's worthless. So that's what we're talking about. We're trying to give this statute the teeth that we believe it was intended to have right alongside the federal statute, Title VII. Now, to talk about this case and what we at Pacific Justice did and what we prepared, I'd like to bring to the program now someone who actually wrote that friend of the court brief that was requested by the appellate court. Alexander Bumbu, thank you for your work. And let's see what you have to say. What's your interpretation of what happened and where this goes from here?
Hi, thank you, Brad. So yes, we filed an amicus brief in Florida's 6th District Court of Appeal. So we filed an amicus brief on behalf of a Christian employee who was fired by his employer for not taking a COVID-19 vaccine. And he had requested a reasonable religious accommodation to that COVID-19 vaccine mandate. He was an HVAC mechanic working for a hospital. And the hospital denied his request and ultimately fired him. And the employee filed a complaint against the hospital. And his case is now in the state court system in Florida's 6th District Court of Appeal, which is an intermediate appellate court in Florida's court system that's one level below the Florida Supreme Court. Now, we do not represent any party in this case. We do not represent the employee, but rather we filed an amicus brief. Now, what is an amicus brief, or an amicus curiae brief, as it is also known? The words amicus curiae are Latin for friend of the court. An amicus curiae brief is a document which an organization or an individual who is not a party to a case submits to a court in order to help the court come to an informed conclusion in favor of one of the parties. So we are not a party in this case, but rather we filed an amicus brief on behalf of the Christian employee. His name is Mr. Marin. And the reason we were able to file an amicus brief is because the court invited PGI by name to file one due to PGI's expertise and experience in religious liberty litigation. And so, in the brief, we had to answer a question that the court posed. And the court asked this question: does the Florida Civil Rights Act, which prohibits employment discrimination, does it require employers to reasonably accommodate their employees' sincerely held religious beliefs? And we argued in the affirmative that it does. And that's an important question because the alternative is that the religious discrimination which the Florida Civil Rights Act prohibits only prohibits employers from treating religious employees differently than non-religious employees or employees of a different religion. So the court has basically those two options. And we argued that, in addition to that, the religious discrimination which the Florida Civil Rights Act prohibits also, the Florida Civil Rights Act also requires employers to affirmatively accommodate their employees' sincerely held religious beliefs. And the point of this amicus brief is to help the court interpret the law correctly, and that is very important in this case because, as you and the audience can probably surmise, there's a huge difference between a law which says only that an employer cannot treat religious employees differently versus a law that also requires employers to reasonably accommodate their employees' religious beliefs. And that's very important because the vast majority of claims of religious discrimination against employers in this country are not that the employer has treated a religious employee worse or differently than a non-religious employee or an employee of another religion, but rather that the employer has not reasonably accommodated the employee's religious belief. And so the law in question is the Florida Civil Rights Act of 1992. And in our opinion, Florida law must protect religious employees in a meaningful way. And for the Florida Civil Rights Act to do that, it must be read to impose a duty of reasonable accommodation on employers. And furthermore, employees should not face termination for living according to their faith. That is an America we like to see here at PJI, where employees are not forced to choose between their employment and their faith. And so there's a critical principle at issue here. And the critical principle is that government and employers cannot force religious compromise. Government employers cannot force religious compromise. And I think, as you and the audience might also surmise, this case has broad implications for all employees in Florida. This is the first time that a Florida appellate court has ever had to answer the question of whether the Florida Civil Rights Act of 1992 requires employers to reasonably accommodate their employees' religious beliefs. Well, the Florida Civil Rights Act has been around for over 30 years, and this is the first time this question has come up before a Florida appellate court. And so this case could set a very important precedent for all Florida employees, which again it could impact all Florida employees no matter what their profession is, be they healthcare workers, teachers, first responders, sanitation workers, you name it. And so we were very glad that we were invited to file a critical amicus brief in this potentially precedent-setting case by Florida 6th District Court of Appeal. Thank you.
Thank you, Alexander. And now it's time for Kyle Cambell to give us the deep dive.
Sharing our faith is deeply personal, and our rights as Americans to worship as we please, express that faith and our religion, and have legal safeguards around those acts is thoroughly protected by our Constitution and the First Amendment to it. But what happens when that expression enters the workplace? Can you talk about religion at work? Can your employer restrict it? And where is the line between religious freedom and workplace professionalism? Well, here in the United States, this issue sits at the crossroads of two important principles: religious liberty and workplace fairness. Understanding the balance between the two helps employees and employers navigate this sensitive topic. So let's break down how the law approaches sharing faith in the workplace. The starting point for this discussion is the First Amendment to the U.S. Constitution, which protects freedom of religion. It ensures that the government cannot establish a religion or prevent people from practicing their beliefs. There's a however built in here, because the First Amendment mainly applies to government action. That means it directly affects public workplaces like government offices, public schools, or federal agencies. In those environments, the government must remain neutral toward religion. It cannot promote religious activity, but it also can't unfairly restrict someone's personal religious expression. For example, a public employee can pray privately during a break, wear religious clothing, or keep religious items at their desk. But a government employer must be careful not to appear as if it's endorsing religion. In private workplaces, the legal framework is a bit different. For most workplaces in America, the most important law governing religion is Title VII of the Civil Rights Act of 1964. This law prohibits employers from discriminating against employees based on religion, and it applies to most employers with 15 or more employees, both public and private. Title VII establishes three important protections. First, employees cannot be treated unfairly because of their religion. That means someone cannot be hired, fired, promoted, or disciplined because of their beliefs. Second, employees have the right to express their religious beliefs in the workplace, as long as that expression is reasonable and not disruptive. Third, employers must provide reasonable accommodations for religious practices unless doing so causes what the law calls an undue hardship. This could include allowing schedule changes for religious holidays, permitting religious clothing like hijabs or yarmulkes, or allowing time and space for prayer. In other words, the law recognizes that religious expression is part of many people's identities. In speaking on this topic to followers of Christ, this verse comes to mind. For I am not ashamed of the gospel, but it is the power of God that brings salvation to everyone who believes. That's Romans 1:16. In just about every case, employees are allowed to share their faith at work in many ways, similar to how they might discuss other personal interests. Let me share some examples of this and how it might go. Employees can typically talk about their faith in everyday conversations with coworkers. They can invite coworkers to attend a religious event or service, keep religious books like a Bible or symbols like a framed verse or cross at their desk. They can pray privately during breaks or lunchtime and can definitely wear religious jewelry or clothing. Courts often treat religious speech just like any other kind of personal speech. If employees are allowed to talk about sports, hobbies, or weekend plans, they're usually allowed to talk about their faith as well. The reason I say usually is that there's a key factor here, and that is voluntary participation. Conversations about religion must remain respectful and not pressure others to participate. Most workplaces aim to create an environment where people of different beliefs or no religious beliefs can work together comfortably. While religious expression is protected, there are also some limits, so let's touch on those here too. Expressing your faith in the workplace can become problematic when religious sharing crosses into harassment, coercion, or disruption. This could look like repeatedly pushing religious discussions. After a coworker has asked you to stop, that could be considered harassment. Another sensitive situation involves power dynamics, especially between supervisors and employees. If a supervisor pressures employees to join prayer meetings, attend religious events, or adopt certain beliefs, that can create a coercive environment. Because supervisors have authority over promotions, schedules, and evaluations, employees may feel they can't say no. Employers also have a responsibility to prevent what is known as a hostile work environment. This means ensuring that no employee feels targeted, excluded, or pressured because of religion. And companies can place limits on any behavior that disrupts productivity or interferes with job duties, whether religious or not. So the balance then becomes protect religious expression while maintaining a respectful workplace. If you're hearing this and thinking, but COVID, yeah, there were many situations during the pandemic in which the COVID vaccine was pushed on employees like a religion, yet religious exemption requests were ignored or denied. PJI has been hard at work, very successfully defending those whose religious freedoms were abused during that time. But back to this issue. Courts in recent years, including the U.S. Supreme Court, have increasingly emphasized the importance of protecting religious expression. A major ruling clarified that employers must make stronger efforts to accommodate religious practices. They can only deny accommodations if they would cause substantial difficulty or expense for the business. This has strengthened protections for employees who want to practice their faith while working. Still, the core principle remains the same. Religious expression is protected, but it must coexist with the rights and comfort of others in the workplace, like we do in every other situation and circumstance in our day-to-day lives. In the United States, employees generally have the right to share their faith at work, but those rights come with boundaries. Employers are required to accommodate sincere religious practices whenever reasonably possible, and religious conversations should be voluntary, respectful, and non-disruptive. As 1 Peter 3:15 says, always be prepared to give an answer to everyone who asks you to give the reason for the hope that you have, but do this with gentleness and respect. Ultimately, the goal is a workplace where people of all beliefs can work side by side with mutual respect without feeling pressured, excluded, or silenced. Understanding these principles helps ensure that both religious freedom and workplace fairness are protected. For those of us whose lives are directed by our faith, the thing that remains at the forefront of our minds and hearts every day, remember, we live in a Christian nation and your religious freedoms and rights are well protected.
He brought up abortion and he was talking about it. And he mentioned, and this connects to our textbook as well, he mentioned that it was okay to abort because it's not a human, it's just an embryo. I think it was fetus was one of those two terms he used. And I said, the problem is that that's just another name for a human, just like you have adult, adolescent, baby, infant, toddler. These are just names for humans at different stages of development. And he then went and left the class to go get a dictionary to prove me wrong.
Oh no.
And that class sat there for like 15 minutes. During class time, he didn't come back. He finally arrives back. He's got a dictionary, but it didn't prove him right. No. I think he must have been looking at every dictionary he could find.
He had to, because it's like fetus is the actual
it's just a little human.
Latin for preborn human baby, or whatever.
Yeah. So he looks it up and it didn't work. And then I was able to use the textbook as well. I said, just because you call this a fetus doesn't change the fact that this is a living human being. The very introduction to our textbook says that language is a system of shared conventions. And then I discussed the meaning of that based on the logic and critical thinking class that we were taking. And after that, he would not let me speak in class anymore. I'd raise my hand and some of the other students were like, let him talk. And he would not allow me to speak.
Wow. Yeah. Wow. But what an impact it had. Maybe not on him, but what an impact it had. Thank you, Kyle, for that very valuable insight.
Imagine living in a world where your right to believe, worship, and live out your faith is under constant threat, where your convictions are challenged simply because of who you are. For many Americans, that's reality. Every day, people face exclusion, discrimination, and intimidation just for living out their faith. That's why PJI exists, to stand with those who can't stand alone, to defend the rights of families, churches, students, and businesses under attack for their beliefs, to be a voice for the voiceless. We're fighting for a nation where faith doesn't have to be hidden, where no one has to choose between their beliefs and their livelihood. But we can't do it without you. Your gift today helps us keep up the fight for freedom, for justice, for faith.
Folks, we at Pacific Justice Institute, we take on these cases and we defend people completely without charge. We charge zero. That's what we do because that's what we're about. So folks, we've looked at the law. Let's take a look at the word. That, after all, that should always be our final authority, our final reference. And we have there's great language in the Bible about workplace, our attitudes about the workplace, as doing it as unto the Lord. Well, I'd like us to turn to just one passage for now, and that's Colossians chapter 3, verse 23. And here's what it says. It says, whatever you do, work at it with all your heart, as working for the Lord, not for men. Sometimes when we go to work, we sort of separate it from Sunday morning. Sunday morning, the pastor can inspire us, can give us great motivation and inspiration to live our faith. And then we go to the workplace and we're like, okay, I'm in a different place. I have a different uniform, a different character. That's not Christianity. We need to go to the workplace. We need to work hard. We need to be exemplary. But we need to be exemplary as unto the Lord, not to just please men. Because when we just put our focus on just pleasing men or pleasing our female boss, whoever, then we're sacrificing what God really wants our focus to be, which is to be pleased of Him. Put Him first and understand what He's given us and where He's placed us for such a time as this. And that's to live our faith, to share our faith, and not to be ashamed of our faith. And by the way, if you do have persecution, if you do have kickback because of your faith, contact us. Contact Pacific Justice Institute. We love to empower people to know what their legal rights are, not just what their spiritual duty is, or, exhortation with regards to living your faith from a biblical worldview, but also to know what your rights are to live that faith. God wants you to be wise and discerning. I don't think God intends us to be martyrs for martyrs' sake. We're to be martyrs to the extent that we're being wise and obedient as unto the Lord, and doing everything we can to be an effective witness, to be relevant in the world and in the place that He's given us, including the workplace. So folks, remember this. No matter how great the risk, no matter how great the struggle, no matter how great the challenge, always, always keep the faith.